Rikers Island sexual assault lawyer claims against New York City. Attorney Andrew M. Stengel. Rikers Island in New York City is one of the most scrutinized jail complexes in the United States. Years of investigations, court oversight, and news reporting have documented patterns of staff violence and institutional failure. Sexual assault survivors at Rikers Island have strong grounds for civil rights lawsuits. We pursue accountability for people who were sexually assaulted while detained at Rikers Island or any New York City Department of Correction facility. A New York prison sexual assault lawyer at the firm can evaluate your situation. A history of documented misconduct at Rikers Island. Federal monitors have reported widespread staff misconduct at Rikers Island over many years. Court ordered reforms have been slow to materialize or prevent Rikers Island's sexual assault. This institutional failure is legally relevant to civil rights claims brought by individual survivors. When a facility has a documented pattern of tolerating abuse, that history supports claims that the institution acted with deliberate indifference. Deliberate indifference is the standard required to hold a municipality or jail system liable. Reports from the New York City Board of Correction and federal investigators have identified specific housing units and staff conduct that created dangerous conditions. Survivors who experienced sexual assault in those environments have compelling legal claims. Legal theories that support your claim in New York City. Civil rights claims under 42 U.S.C. Section 1983 target government officials and entities that violated constitutional rights. The Eighth Amendment protects sentenced prisoners from cruel and unusual punishment. The 14th Amendment extends similar protections to pretrial detainees. A claim against an individual officer requires showing that the officer acted under color of law. Sexual assault by a corrections officer on duty meets that standard without question. Claims against the City of New York for Rikers Island sexual assault require showing that a policy, practice, or custom caused the constitutional violation. A pattern of unreported assaults, inadequate investigations, or retaliation against survivors can establish that policy. What evidence matters in Rikers Island sexual assault cases? Medical records created after the assault are among the most important pieces of evidence in Rikers Island sexual assault cases. Grievance filings, even if ignored, document that you reported what happened. Witness statements from other detainees or staff can corroborate your account. PREA investigation records, if any were generated, are obtainable through legal discovery. Internal affairs files and personnel records for accused officers can reveal prior complaints. An attorney can move quickly to preserve records before they are destroyed or lost. You do not need a perfect paper trail to have a viable claim. Many survivors of Rikers Island sexual assault or inside other New York City or New York State jails never received formal responses to their reports. The absence of investigation can itself be evidence of deliberate indifference. Speak with the law firm of Andrew M. Stengel, PC, before time runs out. Civil claims involving government entities have filing deadlines that differ from ordinary lawsuits. Claims against New York City agencies require a notice of claim within 90 days. Missing that deadline can permanently bar your case. The law firm of Andrew M. Stengel, PC, advises survivors on applicable deadlines and works to preserve all legal options. Acting promptly protects your rights even if the assault occurred some time ago. Schedule a consultation with the law firm of Andrew M. Stengel, PC, by emailing info@stengellaw.com. For more information, please visit our website, stengellaw.com. Attorney advertising. Prior results do not guarantee a similar outcome.